She was middle-aged, not quite middle-aged, a little younger than middle-aged, with 3 children. There was a young girl who had just completed primary school and was getting ready to go into high school. Then a brother, and then another little sister. Maybe the youngest was maybe still just out of nursery, and then the middle one was in primary school, obviously. And the woman's case or story was that.
The microphone is not working.
Oh, okay. It's not working. Okay, it's working now. Okay, sorry. I hope I was heard in the first view. Anyway, so the case was that she had cohabited with the father of her 3 children for several years, because if the first one was ready to go into high school, then obviously at least between 10 and 13 years they had cohabited. The man had decided to move on and marry someone else and had thrown them out. And everything was done to try and get him to look after the children, at least. But the reviews are like, well, I didn't marry you. I stayed with you. I never married you. You had 3 children. I want to move on, and I'm not interested in this. The first child wept. She implored me that at this point she doesn't even know whether she can continue her education anymore, because her mom is not in a position to take care of the 3 of them, and their father is not interested in hearing anything about them anymore because he had moved on, found a new love. That day I left FIDA, and the expression, the weight on your shoulders when something is bothering you, I could literally feel that weight on my shoulder, because there was not a whole lot that you could do for them, just maybe, and FIDA was not too well funded that you can even see if they can find a way of supporting them. And for a few days, I just felt I had failed. I was living the life of those children and feeling like I hadn't helped them. But the law, I couldn't help them because the law does not support the lifestyle that their mother had chosen. I didn't go back to FIDA anymore because it haunted me for so long, and I was like, I don't think I can do this. I can deal with another, because there were several of these stories, maybe some, but this was the one that was the turning point for me. And I just gave up on FIDA. Further down the line and in the years, I thought that was running away from the problem, but at that point, it seemed like the right decision for me to do. Anyway, having said that, on the main subject, we have always viewed our country as a country deeply steeped or rooted in religious, moral, cultural values. And you'll be surprised that cohabitation, it is extremely widespread, because people live together without having gone through the processes, despite all our traditional beliefs, our traditional values, our Christian values, and our moral values. Moral, I use moral in quotes. I'll give some statistics on cohabitation. I'll skip the etymology. I guess we all understand cohabitation, so I don't have to go into that. But can we go back? Where the numbers? Yes, the numbers. In Ghana, currently, we have about 1,622,000 plus who are 15 years and above in informal living, who are informally living together as married couples or cohabiting. 82% of the country's population are cohabiting. Sorry, 8.2. 8.2 may seem like a small percentage, but it's still, the impact is still very heavy. On the regional level, we just sampled a few. Ashanti region topped with 348,000 plus thousand, and then in Greater Accra, 220, almost 295 cohabiting. Then the North, I'm sure, because of the way their cultural, I suppose the cultural dictates still is quite prevalent. So there was just 9,239. So putting it together, it is a good, quite a huge number of people who are cohabiting and a lot of them are under the illusion that, or the belief that in that even though they haven't gone through the processes, they are married. And unfortunately, it is when one partner dies, usually the women are the disadvantaged people, that they find out that no matter how many years you have invested in that relationship, your rights are limited, if any at all. The next slide, please. So we all know that in Ghana, marriage is an arrangement involving a male and a female that is governed by laws, traditions, and religious convictions. It is a voluntary union for life of one man and one woman to the exclusion of all others, despite our potentially polygamous life we have. Being married is governed by rules and regulations, and the celebration of the marriage, whether customary or ordinance, has some procedures that have to be followed. The previous presenters made reference to some of these procedures that have to be followed to make a marriage legitimate. So the marriage is not the same as cohabitation. We have to emphasize that. I just had a brief discussion during the lunch break with a few of this thing, and the discussion centered around, so maybe you're cohabiting with someone, your in-law recognizes you as muscle and all of that, and so you believe that you are married, and then the partner dies, and you find that you are, as the young people say, you are left ajar. There's nothing for you to do, under the law to protect your interests and the time invested in that relationship. So marriage, therefore, is not the same as cohabitation. And long cohabitation generally does not mean marriage. It's something that is very important that we must all keep at the back of our minds when you're advising people who are in that kind of relationship. In Ghana's jurisprudence, there are 3 types of marriages that are recognized under the law. There's the marriage under the ordinance, which we all know, Registrar Generals, all of that, Mohammedan marriage, and then the customary marriage. Under the customary marriage differs from, the country has a lot of ethnic groups. So every ethnic group has, it's just slight variations of the same theme, the family, but and we always say that in Ghana, marriage is not about just the individual, like out in the developed world where 2 people can decide, okay, we want to get married. They give the rings, they do all of that and decide that we are married. Here, the family has to be involved, and that is what legitimizes the marriage. Okay, so like I said, since legal formalities for marriage are not, under Ghanaian law, cohabitation, like I said before, is not recognized as marriage. And this is because there are legal formalities that have to be fulfilled for the union to be considered as a marriage under the Ghanaian laws. A person who is not the husband or wife of the deceased, according to the laws in marriage, doesn't matter how long you entered into that relationship, it's not under our laws entitled to any part of the whole of the portion of the spouse or the spouse's properties once the partner has departed the earth. Okay, can we go? So this is just, like a repetition of, or I've made reference to that. So cohabitants are not recognized as beneficiaries under Ghana's interstate succession laws. And the position is reflected in the Constitution, the Interstate Succession Law, PNDC Law 111. The High Court Civil Procedure Rules does not recognize cohabitation, and the Marriage and Matrimonial Causes does not recognize that either. The Constitution, however, recognizes spousal rights, not concubinage or cohabitation rights under Article 22. So spousal rights and not cohabitation or concubinage. Similarly, the interstate succession law recognizes only the lawful spouse of the deceased, not girlfriends or cohabitants. As I said, I'll make reference to a situation analysis carried out by, let me just get the name right, the Gender Asset Gap Project. And this was spearheaded by Mrs. Dorcas Kokapia. They did an analysis of this was in 2011. They did an analysis of PNDC Law 111, picked out the shortfalls or the gaps in there and made recommendations towards how it can be improved. That was 2001. As my life patron and our chairperson said, Kebashi, those changes have not been effected. It's the same, we are still dealing with the same gaps and the same shortfalls in the law. And those rights that one was trying to see, what word should I use, rectified, are still not, they are non-existent. You don't have those rights. And next slide, please. Okay, sorry. There's quite a number of case law. Can we go to the previous slide, please? Quite a number of case law to underscore the fact that cohabiting does not legitimize the relationship. And in the case in Asante disease, Owusu versus Asante, the court refused to grant letters of administration to the unmarried plaintiff of the deceased. The court stated that a concubine or a cohabitant has no legal standing in matters of interstate succession. They are not spouses and cannot make legal claims in case they are denied access to the estate of the deceased. And again, we go back to our traditional, once, especially, we can speak for the Akan tradition. Once the man dies, the inheritance, if he dies intestate, inheritance is they are matrilineal. So uncles will come in, take over the property through the spouse. But in this case, because we are talking about cohabitant, assuming they are living together fully, almost like husband and wife, throw the partner and the children out and claim the property as theirs to administer the way they want to administer it. And at the end of the day, the children, most of the time, are left, the woman is left destitute, and by, especially if they are underage, their life is turned upside down, and they may not even continue education or anything. So, so in this case, this is what happened. That you were not a wife, you were a cohabitant, and so you have no rights under our laws. Sad as it seems. Can we move on to another case study? In Owusu versus Nyako, the court refused to recognize the concubinary as a form of marriage. In this case, the plaintiff herself's father, had agreed and told them that they can live together because the prospective son-in-law did not have the wherewithal to come and conduct the traditional, rights to marry her. So he endorsed it. He gave his blessing that they should live together, as cohabitants. And the court held that since the two did not perform the customary rites, there was no marriage. And their cohabitation did not morph into customary marriage. She was therefore refused benefits under the estate of the deceased. And again, we are very particular about, once an individual dies, inheritance rights and all of that. So if this kind of situation arises, and despite the fact that he had the father's blessing, but customary marriage is the families. So nobody from either side of the family came to see the other side of the family and said to them or presented what was required, that yes, our child is marrying your child. So it's a legitimate it's a legitimate way for them to stay. They have rights under that one. That was not performed, despite the fact that the father was the one who, and my question when I read that was, what father would ask their daughter to, why would you do that? Ask it, no matter what, because, yeah, but that was it. And unfortunately, this was the end that the lady found herself in. There was a very recent case this year, and Sarah Pinto versus Ayiku Pinto and 5 others. The court refused to grant the deceased person letters of administration. Why? Because they got divorced before the man died. However, after the divorce, they still lived together. But they had officially or legally divorced each other. And the fact that they were still living together didn't negate their legal standing at that point in time. So she had no locus to go and apply, because then the marriage had become cohabitation at that point after the divorce. So the court refused. These are some of the things that at AWLA, you sit down and think that we have a lot of work to do in trying to change some of these things, that some of the laws to protect the interest of people. It's not only women. There might be men too who may have cohabited with a woman who is who became a person of substance, but because they were not married. As soon as, I'm sure the family will be sitting back and thinking, you sit down and think that you have rights here. If this woman dies, you are not going to. So it cuts both ways, although the majority of the times it is the women who are the people who suffer the most. Okay, so we go. Why do people engage in cohabitation? The world has changed. We send our children out to schools outside. Maybe if they were at home, you would not approve of them. They may have their boyfriends, their girlfriends, and all of that. But you, as a parent, most parents will not approve of living together. You may come and spend time with each other while they are in the universities and things. You cannot control that. But when, most parents will not subscribe to that kind of life. But more and more, it is happening, even here. Parents may know that they are doing that, but look the other way. Because if you tell your child that you can't do this, say that, but when I was in the US, I was living with a person, you were here, that kind of. So it's becoming more prevalent with modern times, and of course, all the world as it is now, they are exposed to a lot of things. Even if you haven't been anywhere, you go on your phone, you read all kinds of things, and you think it's doable. So the cultural values and the religious values and the customary values are being diluted. Whether for good or bad, that's subject to debate, but that's what's going on. So one of the other reasons will be high cost of formal marriage. The high cost of formal marriage ceremonies discourage some couples from getting married. So, like the example I gave, the father said the prospective son-in-law cannot afford to come and perform the rites, so you go live together. And so they live together. And then at the end of the day, the woman and the children from that union will find themselves in a very uncomfortable situation. The social and cultural shifts, I've already made mention of that. Then economic convenience leads to partners sharing living expenses without formalizing the relationship. And I think, and more, we see people who just decide that we're just comfortable with this relationship, so we just want to continue that way. We don't want to commit to marriage, which is fine. Again, it comes back to the same thing until there is something happens, because you've invested your time, you've invested your resources. Both of you have invested your time, your resources into your life together, but everything that you've done is not supported by law. So when at crunch time, you just lose out. Partners in cohabiting relationship lack legal, like I said, they lack legal protection in cases of separation or death. It exposes women and children in such unions to economic vulnerability after separation. It increases litigation over property disputes, since the law provides no clear framework. And that's one. I would even amend it to say that the law does not recognize that kind of living situation at all. So definitely there is nothing to regulate or to support that kind of living relationship. It fails to reflect evolving social realities. Again, things are changing worldwide at a faster pace than we can breathe, but our laws are not changing. And unfortunately, until the law is changed, if you go to court, the judges would have to apply the law as it stands. They cannot, it's not discretionary. They have to just apply the law as it stands. And then it says that research shows that women in such relationships are more likely to be abused, because he knows that nobody can hold, or the men in those relationships. I won't want to generalize, but the situation is that in the event of anything, it's like, well, I don't, it's maybe domestic violence, just as it is, may protect women, but if it should happen. But otherwise, there's barely any protection, and women are subjected to a lot of violence in such relationships. What can cohabitants do when the relationship ends? That is the major thing. Although cohabitants are not entitled to marital rights under Ghana law, a cohabitant may, in certain circumstances, pursue civil claims when relationships break. They may claim, breach of promise to marry, recovery of assets or financial contributions made during relationships, and restitution for unjust. Yes, I'm almost done. I think there's 2 more slides. Unjust enrichment. So recovery of, in all of these, if you're going to claim this under civil law, you still have to, he who claims has to prove that this is it. So you should have documentation to prove that this all, you were in this relationship, you were cohabiting, but, and then even in breach of promise to marry, that would be a difficult sell, but you can, I read a case where it was like, okay, the person said so, but it was not a contract. So that, even that failed. There was proof that the person sent a message that, yes, I'm going to marry you. The partner had traveled out. And when I get back, we are going to get married. But he said so. As for words, they're free. You can just, it was not a contract. So that was not taken by the court. These claims, however, are guided in general contract or property law principles rather than matrimonial law. Okay. Can we go to the next slide, please? So there are case laws to support all of these. And then recovery, where unmarried partners acquire property in the name of one partner, the other may be regarded as a co-owner if it is established. through their conduct or statement. It's all, just what I just made reference to. Can we go to the next, please? More case study. Can we go to the next one? What does the law say in other jurisdictions? So we did the comparisons. I mean, generally, cohabitation is not recognized in most jurisdictions. It's not recognized in Malawi and Tanzania. Malawi and Tanzania recognize such unions or relations as married by, yes, Malawi and Tanzania does recognize. Tanzania, where a man and a woman have lived together for 2 or more years, the law shall presume they were married. In Malawi, recognizes permanent cohabitation as a form of marriage. In Seychelles, it's not recognized in Seychelles, but there are other protective laws for people who find themselves in this situation. Can we go to the next one? Sierra Leone, our neighbors, they have, if you've lived together for 5 years, and it is proven, it's known that you've lived together for 5 years, they recognize you, it converts it to a marriage. In Kenya, the relationships are not recognized. However, they are recognized by courts. So in Kenya, if you went to court and prove that you have cohabited for some time, the court will make, and for claims on property and things, the court will take it into consideration that you have invested time in this and will find accordingly in your favor. Can we go to the next one, please? UK. Common law marriage is not recognized by law in England and Wales. However, assets can be recovered in the UK. So when we look at it, very few countries recognize cohabitation. It is not converted to marriage, under the laws, just because you have cohabited. Can we go to the next one, please? Okay, so the recommendations. Before I do the recommendations, I have to recognize or mention AWLA's former executive director, Edna Kuma of blessed memory. They did a lot of work on these things, trying to, have the laws changed, and dedicated her whole life to advocating for some of these changes. And AWLA itself went up and down the country from north to south, educating women, advocating, and doing advocacy on all of these situations. But unfortunately, there's not much change that has occurred since. So the recommendations that we would make, Ghana may adopt legal presumption of marriage after a defined period of cohabitation. This was, I think, in one of the bills, interstate succession or the property rights bill, that this should be looked at, but it was kicked against vehemently, and of course mostly by the men in parliament. Ghana can enact legislation to protect the economic interest of parties in cohabitation unions, as Seychelles or Sierra Leone, and then Ghana can convert long-term cohabitation into customary marriage through legislation, as in Sierra Leone. So, I think on this note, if these recommendations can be taken into consideration, it will generally help, in the life as it is, because it's evolving, and we have to recognize the fact that despite the religious, moral, and cultural dispensation of the country, life is moving on, and we need to move on accordingly. Thank you.
Thank you. Let's give her a round of applause. Thank you very much, Madam Kristine Lartey Esq, for doing justice to this topic.